Welcome back to the video lecture on East Asia's cultural influence on the law of the sea. At this time, we are going to have a level session to discuss the whole classes we have in terms of the East Asian state leadership in international law and in Korea. The development internationally in Korea is traced back to the late 19th century, when Korea was confronted with public international law introduced by the Western imperial states and further influenced by the Japanese colonization from 1910 to 1945 and U.S. military administration in the southern half of the Korea from 1945 to 1948. The Republic of Korea was formally established in 1948 with the adoption of its first constitution. The history and legacy of Korea play an important role in shaping the contours of the Korea's legal system as well as Korea's international relations. The legal system of Korea particularly underwent the drastic changes during Japanese colonial rule as the Japanese government tried to apply their civil law system based on the continental, the European legal system to Korea. Such legal changes imposed under the colonial rule created challenges because Korea was faced with conflict between its deep-rooted Confucian traditions and the newly incorporated European-oriented legal principles. After Korea gained its independence in 1948, the issue of reconciling the Confucianism and colonialism Korean law was additionally intertwined with the noble principle of constitutionalism that came about due to the growing influence of the Anglo-American legal system in Korea. Korea's approach to international law is explained through the interpretation of its constitution, which stipulates in relevant parts that the treaties duly concluded and promulgated under the constitution and the general recognized rules of international law shall have the same effect as the domestic laws of the Republic of Korea. In accordance with this provision, the international law has been generally accepted as Korean domestic law and incorporated into Korea's domestic legal system. While the Constitution expressly set forth that treaties duly concluded are accorded with the same status as the domestic law of Korea, there is no specific mention of the customary international law. The term generally recognized rules of international law is largely interpreted to mean customary international law. Regarding the status of international in Korea's domestic legal system, the prevailing view is that both treaties and customary international law stand equal with domestic legislations. While the treaties ratify the consent of the National Assembly are deemed to have a status equal to statute passed by the National Assembly, those simplified treaties without legislative consent are deemed to enjoy the same status as decrees issued by the President and various ministries and enforcement decrees under the statute. The tumultuous experience of Korean nation in the 20th century within the context of the international relations in Northeast Asia has had a significant impact on Korea's attitude toward the practice of public international law. Korea has many issues to be settled under international law. Such issues include, but not limited to, territorial dispute with neighboring countries, issues of transitional justice, and issues regarding the limitation of maritime boundaries and fisheries. As to adjudication as a means of dispute settlement, Korea has not recognized the compulsory jurisdiction of the International Court of Justice, ICJ. However, Korea has accepted compulsory jurisdiction of the ICJ for disputes arising out of the interpretation and application of the optional protocol to Vienna Convention on diplomatic relations concerning the compulsory settlement of disputes, as well as the optional protocol to Vienna Convention on consular relations concerning the compulsory settlements of disputes. Korea, as a party to the UN Convention on the Law of the Sea, UNCLOS, submitted a declaration under UNCLOS Article 298 in 2006. Korea generally remains inactive in employing international adjudication as a means of the settlement. Moreover, Korea has not employed non-judicial means of this settlement, such as inquiry, mediation, or conciliation. The only bilateral agreements concluded for the purpose of this settlement is that exchange of notes concerning the settlement dispute concluded between Korea and Japan in 1965. One of the possible explanations for Korea's rather confined choice for the settlement is the most issues at stake are delicate related to territorial matters, which can never be easily left for a third-party decision. As a full-fledged member of the international community, Korea has been actively involved in a number of activities at the international organization and conferences. Korea particularly devoted to multilateral diplomacy at the UN and gradually pursued bilateral diplomacy even in the multilateral forums such as the G20 summit. Moreover, Korea utilized its UN diplomacy to extend the scope of its global participation in major global agendas, including but not limited to human rights, environment, terrorism, and poverty. The hosting of major international forums such as the G20 Seoul Summit, the 2012 Nuclear Security Summit, and the fourth high-level forum on aid and effectiveness in 2011 to show the Korea's national capacity to serve not only as a global agenda setter, but more importantly, as a bridge builder between developed and developing countries. Korea's engagement with the international community extends to humanitarian and disaster relief effort through its participation in the UN peacekeeping missions. Korea's experience in international relations is rather unique in the sense that Korea emerged not only from Japan's colonialism, but also war-torn country to become an Asian power. Some significant international legal issues, including those which resulted from the Japanese occupation of Korea, as well as from the Korean War, are highlighted in this lecture. Thank you very much for your attention.